Yes,
Decided to take, we have taken so much of cognizance
my lords.
of this matter because we are pained by the observations which were made by the single judge, of the High Court of Punjab and Haryana while training proceeding in the exercise of the contempt jurisdiction. The observations made in regard to an order passed by the Supreme Court.
This one.
And of course, there is also now a video clip which has been circulating, but the order is a part of the public record of the High Court.
Regarding video clip, I have some facts which I have gathered from members of the bar, my lord, from there, who are connected with the case, my lord.
Yes.
And there is something more, when your lordship permits, my lord, I may present it for your lordship's
The
consideration.
Learned Attorney General is also, I think he has joined online, but
He has joined.
the Learned Attorney is traveling today.
He is not in there.
Perhaps
I'm here before your lordship, sir. I took leave from the High Court, was appearing to present myself before your lordships, and I have read the entire proceedings. I think this matter deserves an intervention by the Supreme Court. There are many dimensions to what the learned judge should not have done, and while preserving the importance of the High Court, not as a subordinate institution to the Supreme Court, but at the same time, I think there is some transgression which is unwarranted. I think the court may have take a serious note of that.
Lord, so far as the video is concerned, Lord, I would request your lordships to see it in a particular factual context, which, my lord, in my submission, makes out a case for an aggravated contempt. My lord, I'll just give the background which are necessary, my lord, background facts necessary for the present purpose.
Yes.
Lord, this is post the judgment which your lordships have. What happened was there was a dispute between A and B regarding a plot of land with which we are not concerned, and a contempt petition was filed which came before the learned single judge. There, my lord, the contempt jurisdiction is before the learned single judge. The learned single judge exercising contempt jurisdiction could have either convicted or not convicted. But the learned single judge decided to say that neither A nor B let the land be vested in the government. That led to filing of a contempt appeal before the division bench. The division bench, my lord, was confronted with a preliminary objection by the other side that section 19 of the Contempt of Courts Act appeal lies only when there is a conviction. This appeal is not maintainable, and the appellant was arguing that this direction that land be vested in the state government could have been issued only in exercise of the learned judge's power under Article 226. Therefore, appeal is maintainable. The division bench felt that all right, we'll decide the question of maintainability. In the meanwhile, we stay that part of the order whereby the land is vested in the government, and we request the learned judge to adjourn the contempt proceedings beyond the day which we have fixed. In that context, my lord, this order, my lord, I have given the facts, my lord, I have prepared a chronology of events from, my lord, members of the bar, my lord, and I believe this to be accurate. I'll not read, my lord, every part. Kindly come to page 2, column number 8. My lord, this is the order of the division bench. Your lordships have, my lord,
Yes.
page 2, column number 8. 28th July 24, order of the High Court, contempt.
Just one thing.
Yes, my lord.
Are we required to go into the facts?
No, your lordships are not. I'm going to say something else.
Just one. You're not required to go into the facts and what is the appeal pending.
I'm not on that.
Only issue is the when there is a stay order passed by the court, which directs the stay of the contempt proceeding, being the appellate court, the hierarchical system we have, not that the High Court is subordinate to in a way, but we have the appellate forum system. So that order has to be complied with.
Correct.
The last paragraph does say that, but unnecessary observations have been made with regard to so many things which are not germane to that.
No, give me 2 minutes, my lord. Lord, in the video, now what happens is, the learned judge does 5 things. First, he says this order of the division bench is rubbish. the order which I said, which, my lord, in my respectful submission, could not have said. Second, he says, I refuse to follow that order. That, my lord, aggravates. Third, my lord, he says that you do not know, I have already declared one Supreme Court judgment to be non-est, which is before your lordships, and I have also declared one another division bench judgment to be non-est. That is, my lord, in the video. That I have nullified the order of the division bench, some other order of the division bench. Then, my lord, the learned judge says that judges are required to be sent for judicial training in the video, and my lord, sometimes expressions speak louder than words, and we have seen, my lord, the video. So, my lord, your lordships would take a call whether, apart from, my lord, a very serious case of non-compliance with this order, whether, my lord,
As far as, I think I'll just take just this also. The video part we saw one part of it, maybe one word which you said initially was certainly mentioned. Other parts we did not, we're not aware of.
yes, well, kindly see that because video is in circulation, a common man is watching that video, and these are the 5 facts which I found to be not just judicial indiscipline or judicial impropriety, it is contemptuous. And therefore, for giving the background of understanding the video, I am giving these facts. No, not that we are concerned with the facts of that case.
Mr. Solicitor General, what subject to my colleagues have to say, what we may do is that we are also informed that the High Court, the division bench of the High Court presided over by the Chief Justice, has taken suo motu notice of the order which was passed by the learned single judge, and that order has been stayed by the division bench. Notwithstanding the fact that that order has been stayed, we are of the view that we are not really about a particular judge or a particular order.
No, it's
But this tendency of making gratuitous observations on the work of the Supreme Court, because all high courts, all district courts work in a hierarchical judicial system. They've all been judges of the High Court. And that discipline has to be maintained. There is no occasion for a judge of the High Court. Judges are not aggrieved by any orders which are passed by a superior court.
Absolutely, absolutely.
They have to maintain the discipline of the discipline of the system.
correct.
And therefore, what we would propose to do is that we will expunge the remarks contained in the order of the judge, and expect, and as you have said, that the observations which have been made in the order are scandalous. They would have a bearing on the exercise of the contempt jurisdiction by this court. Equally, as courts at the apex of the system, we must also exercise our powers with great caution, because
That's right.
because the remedy which we craft should not do greater damage to the judicial system. Equally, we are conscious of the fact that though you have aberrations like the order which has been brought to our notice, the overwhelmingly large number of judges of the High Court exercise their judicial work with a great deal of responsibility,
Yes,
notwithstanding the
doubtless
overwhelming pressure of work which all High Court judges have to face. Therefore, we will not make any observations which will in any way affect the majesty of the High Courts as an institution. But surely, I think we have to exercise our jurisdiction and ensure that these observations should be expunged so that they do not remain.
entirely your lordship's wisdom. Only, my lord, my concern was that the video is doing rounds. My lord, that also can be examined by the division bench.
Mr. I learned that Justice Rishikesh Roy wants to put some.
Yes,
Solicitor, the 3 or 4 things that you have mentioned there, they are not part of the actual order that is recorded by the learned judge.
my lord, what
These are part of the proceedings, as you have mentioned in the video. So, in course of the proceedings, sometimes things are said and they are depicted and they are portrayed. But we are really concerned with what eventually is written down in the order of the learned judge. Now, obviously, as you have rightly pointed out, these orders could have been avoided, that kind of sentences, that kind of tone, tenor, even from there, as you said, the words spoken speak louder than words written. Well, perhaps you are right in that, but eventually, when we sit in the Supreme Court, we have to go by what is written down in the order. After all, the proceedings in the court are proceedings where we normally say that free flow of exchange between the bar and the bench.
No, I bow down, my lord. It's your lordship's wisdom. I am not, my lord, for or against anything, but the video which is, my lord, viewed by everyone is post this judgment, where the learned judge says that you do not know. I have even nullified I have declared even Supreme Court judgment, that is this order, to be non-est, and one division bench order to be non-est, and all judge, my lord, it,
Now, that video which has been recorded is while hearing which proceeding actually?
hearing, my lord, proceedings where the division, as I pointed out, the division bench said that you have transferred the land to the government, which we stayed.
This was in response to the order of the division bench directing the adjournment of the proceedings.
Yes, my lord. That's what, my lord, the learned judge says.
Declared by the division bench.
It was
Yes, yes. So there are two division bench judgments, my lord, the learned judge is referring to, that I have nullified them, and even Supreme Court I have said that it's a nullity. It's a non-est order.
Honest.
And say that all our, he is talking about the peer brother judges, that they need to be sent for judicial training, etc.
While
Presiding over the court, he is the master of that particular court.
Correct.
And he adjudicates the matter before him or her. And eventually, if you really look at it in a larger perspective, even the Supreme Court is not supreme, the High Court is not supreme, the Munsif is also not supreme. The supremacy is actually of the Constitution.
Absolutely.
We are all below the Constitution, and our task is to interpret the Constitution as we understand. And that is what the task
And
of the court is.
144, that everyone should
And
work in aid of the Supreme Court of
Supreme Court orders. Right, you are right there. 144 is a very glaring instance.
I only two reflections to share with the court.
yes, Mr. Attorney.
One that while the court exercises the power under Article 129, it is not necessarily bound by the Contempt of Courts Act and all those finer nuances of scandalizing the court, etc. It is a feel of the court in the context of a particular instance as to what may constitute interference with the administration of justice and lowers the integrity of the institution, both of the High Court as well as the Supreme Court. Here I find the learned judge, in fact, has brought down the integrity of the institution of the High Court as well. Therefore, that's how one has to look at it. In whichever way, without further damaging the fabric of the institution of the High Court in the hierarchy, I think whichever way the court would like to intervene, I think the court may like to follow that.
It's entirely my lord's wisdom and discretion, but now we are in the era of live streaming. And this is how it is recorded, my lord, and the video is doing rounds. That's my concern.
Serial number 301, we find that there are two lawyers who have connected from Chandigarh, perhaps, Mr.
Lord, I am the counsel in the SLP, in fact, in which the contempt proceedings were stayed. So I thought it's my duty to be here, my lord, as an officer of the court. I was the counsel in the SLP, my lord, for the petitioner.
Anybody else who's online? He's the only person. This court has taken up these proceedings. The court has taken up these proceedings so motu, the context of an order dated 17 July 2024, passed by Justice Rajbish Therawat, judge of the High Court of Punjab and Haryana, while entertaining a contempt proceeding titled as Naughty Ram versus Devendra Singh IAS and another, COCP 87-2022 bracket O and M. Full stop. The underlying facts which gave rise to the contempt proceedings are not a matter which needs to engage the attention of this court. Full stop. However, while dealing with the contempt proceeding, Justice Sehrawat has made observations in regard to the Supreme Court of India, which are a matter of grave concern. Stop. Since the order forms a part of the public record of the High Court, it is unnecessary for this court to extract those observations, particularly given the course of action which this court proposes to adopt. The principles governing the committee between the High Courts and the Supreme Court as the apex judicial institution in the country have been dealt with in numerous decisions of this court. Stop. May only be full stop. We may only reiterate the principles which have been laid down in the decision in Tirupati Balaji Developers versus
These are all the decisions, if your lordship would like to note. I have compiled.
2004, 5 SCC, page 1. Stop. Judicial discipline, particularly in the judicial discipline, the context of the hierarchical nature of the judicial system is intended to preserve the dignity of all institutions, both the district of all institutions, whether the district, High Court, or at the level of the Supreme Court. Full stop. Full stop. We are of the view that the observations which were made in the order of the single judge dated 17 July 2024 were totally unnecessary for the ultimate order which was passed. Stop. Gratuitous observations in regard to previous orders passed by the Supreme Court, or for that matter, in the course of the same proceedings, are absolutely unwarranted. Full stop. Compliance with orders passed by the Supreme Court is not a matter of choice, but a matter of a bounden constitutional obligation, bearing in mind the structure of the Indian legal system and the authority of the Supreme Court, which heads the process of judicial adjudication in the country. Stop. In passing its orders, including orders of the nature that gave rise to the observations of the single judge, this court discharges its plain duty. Full stop. Parties may be aggrieved by an order. Full stop. Judges are, however, never aggrieved by an order which is passed by a higher constitutional or appellate forum. Full stop. The observations, full stop. The learned Attorney General for India and the learned Solicitor General have, while dilating on the background of the case which led to the passing of the order dated 17 July 2024, have submitted that the order of the single judge has has affected the dignity not only of this court, but of the High Court as well. Full stop. As we have already noted, this court was constrained to take suo motu notice of the facts set out of the contents of the order dated 17 July 2024, passed by the single judge, in view of the fact that such observations tend to bring the entire judicial machinery into disrepute. Full stop. This affects not only the dignity of this court, but of the high courts as well. Full stop. We are accordingly of the view that such observations were wholly unnecessary for the conduct of the judicial proceedings before the High Court and ought to have been eschewed. Stop. We are inclined to exercise our, though there's merit in the submission which has been urged by the Learned Attorney General for India and the Learned Solicitor General, we are inclined to exercise a degree of restraint in pursuing a further course of action based on the observations of the single judge. Full stop. The court is apprised of the fact that the division bench of the High Court, presided over by the learned Chief Justice, has taken suo motu notice of the observations made by the single judge and stayed the operation of the order. Full stop. Notwithstanding the forced exercise which has been carried out bona fide by the bench presided over by the learned Chief Justice, we are of the view that in a situation where the authority of this court is sought to be undermined by gratuitous observations made by a single judge of the High Court, it is a plain constitutional function of this court to set right any attempts to dislocate the sanctity of judicial hierarchy and the maintenance of judicial discipline. Full stop. We accordingly expunge the observations which have been made by Justice Rajveer Sehrawat in the order dated 17 July 2024 and expect that greater caution should be exercised in the future while dealing with orders of the Supreme Court. Full stop. The Supreme Court, and for that matter, the orders passed by the division bench of the High Court. Full stop. Whether individual judges are in agreement with the merits or otherwise of an order passed by a superior court is besides the point. Full stop. Every judge is bound by the discipline which the hierarchical nature of the judicial system imposes on the functioning of every judge and court within the system. Is personally affected by the orders passed either by the division bench of the High Court or, as the case may be, by the Supreme Court. Full stop. In the circumstances, full stop. The order dated 17 July 2024 is compounded by a video which has been circulated indicating random, gratuitous, and unnecessary observations made by the single judge during the course of the hearing.
Scandalous also.
I
I leave it to your lordship.
In an age where there is widespread reporting of every proceeding which takes place in the court, particularly in the context of live streaming, which is intended to provide access to justice to citizens to the proceedings in the court, it is all the more necessary that judges exercise due restraint and responsibility in the observations which are made in court, in the course of proceeding. Full stop. These observations, full stop. These observations of the nature which have proliferated in the video of proceedings before the learned single judge can cause incalculable harm to the sanctity of the judicial process. Our best is to stop. We hope and trust that such circumspection would be observed in the future. Full stop. We would have been inclined to issue notice to the single judge of the High Court, whose observations form the subject matter of the order dated 17 July 2024. Full stop. Doing so, however, would place the judge in a situation of being subject to a judicial adjudication or inquiry by this court, which we are inclined to desist from doing at this stage. Full stop. However, this court, in the exercise of its affirmative obligation as a custodian of the adjudicatory process, would be failing in its duty if it were not to intervene by expunging the remarks which we hereby do. Stop the remarks which were made in the order dated 17 July 2024 are accordingly expunged with an expression of caution that such an exercise, that we hope that it would not be necessary for this court to intervene on another occasion in the future, either in relation to the same judge or any other court in the country. Mr. Solicitor,
Please,
thank you. Mr. Attorney, thank you. I quite understand that you are busy in an important case in Karnataka, and thank you for taking time and for
It's my pleasure to assist the court.
Thank you.
Right.
Before we rise, I'm inclined to give the last word to Brother Justice Rishikesh.
My lord, we also wait for that, my lord.
So actually, the Solicitor General was mentioning about the perils of live streaming. Now, everybody may have a own take on the perils of live streaming, but I have one question. It gives very serious advantage to those who are photogenic.
Yes, yeah, your lordships are right, my lord. Obliged to lordship.
Okay, we'll go. You can tell them in 5 minutes.
I've already,
Yeah.
I spoke to
Yeah.
Advocate General.
Okay.
balcony
Same.
drawing